A North Carolina County prosecutor says the fatal shooting of Andrew Brown Jr. last month was justified, and the sheriff's deputies who killed him will not face any charges. He also showed body camera footage of the shooting to the public for the first time. Deputies fired several shots as Brown was behind the wheel of his car during an attempt to serve him a warrant. His family is demanding federal charges be filed. Jeff Pegues has details from Elizabeth City.
There is likely hours of body camera footage of this shooting, but whether we actually see that footage is going to be up to a judge. Yesterday, the district attorney in this case released just 44 seconds of what he believes is critical body camera footage from 4 different angles. What you're about to see is disturbing. Body camera video shows heavily armed deputies sitting in the back of a police pickup truck. They pull up on Andrew Brown Jr. to serve a drug-related warrant. Go, 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 go! Brown is behind the wheel of the blue sedan as deputies close in on him. Brown then backs the car up and turns to the left, away from officers. Deputies open fire, and the car speeds away before crashing into a tree. District Attorney Andrew Womble says Brown's attempt to flee made his vehicle a deadly weapon.
Mr. Brown's death, while tragic, was justified because Mr. Brown's actions caused 3 deputies with the Pasquotank County Sheriff's Office to reasonably believe it was necessary to use deadly force.
Womble says Brown's car made contact with one of the deputies. In total, they fired 14 shots, hitting Brown in the right arm and the back of the head. Brown was unarmed.
You're saying he was threatening them, but then he's backing away, and it's the officer going for the car.
That is a threat. And I don't care what direction you're going, forward, backward, sideways. I don't care if you're stationary, and neither do our courts and our case law.
The district attorney's press conference was an attempt to whitewash the unjustified killing of Andrew Brown Jr.
Ben Crump, one of the Brown family attorneys, says Brown was trying to drive away from deputies and pose no threat.
The most cowardly thing you could ever do is shoot a person from behind where they're not posing any threat or harm or violence to you.
In that press conference, the DA was adamant about what he believes are the facts of this case, that Brown, in reacting the way he did to approaching deputies, used that vehicle as a deadly weapon. And there have been some cases in the past where the vehicle in the case, in any kind of encounter with police officers, has been viewed as a deadly weapon. But it is also important to note that just 3 of the 7 officers fired those 14 shots, which raises the question of whether the other officers involved, the 4 other officers, didn't view the threat in the same way. Vlad, Anne-Marie.
All right, Jeff, thank you very much. So joining us now is Harry Daniels. He is a civil rights attorney and one of the lawyers representing the Brown family. Thanks for joining us. Mr. Brown was not armed, but the county DA said yesterday that he did use the car as a deadly weapon when he tried to flee the scene. You saw the body camera footage. I want to get your response to the DA's assessment of the situation.
Good morning. Thank you for bringing me on. Anybody who believed that Mr. Brown used that vehicle as a weapon, you are the problem of what's wrong with America today. So I would speak directly to the district attorney. If he thinks that vehicle was weaponized, then he is the problem what's wrong with America today, and why we continue to have no accountability for the killing unarmed people in America.
So, Mr. Daniels, one of the things...
Because sorry, Mr. Daniels, sorry, Vlad, because what did you see occurring when you watched the video?
I saw what everybody else saw. I saw the officers encountering Mr. Brown. Mr. Brown appeared to be afraid. He backed his vehicle up. And at the 4th body cam, you can actually hear a shot when the vehicle is actually backing up. Mr. Brown turns his vehicle, not at a high pace, away from law enforcement. At no time did I see him try to make contact with law enforcement. What you see is one officer touch the head, and he's attempted to get away and go across the vacant lot. You see a barrage of gunfire. There's no justification to that. the most objective evidence in the video, it seemed like the district attorney is trying to throw these fake punches for you to fall for it. Whatever motive, whatever reason he's coming up with, the legalese and the things he's trying to bring in, the law. I don't know what law he's looking at or what law he's reading, but I know the law very well as a civil rights attorney. I've been a criminal defense lawyer before myself. I don't know what he's talking about. And a lot of legal analysts around the country, around the world, have no idea what this man is talking about. He wants you to believe what he is saying, not what you see. So our opinion is just like everybody's opinion. There's no justification, and we double down that this Andrew Brown was executed on April 21st, 2021.
Mr. Daniels, one of the things, and this goes to Anne Marie's follow-up question, one of the things that the North Carolina County prosecutor said yesterday, he mentioned in several instances some Supreme Court precedent about police officers firing at vehicles, and that there have been a number of cases, not just at the Supreme Court level, but at the state level, that have decided that it's okay, that it does merit qualified immunity for police officers if they do shoot at a vehicle, if they perceive it to be a weapon. And then there's one in particular that I was just researching on my own. So I'm not an attorney, so that's why I'm asking you. Back in 2015, the Supreme Court ruled or gave an opinion on Mullenix versus Luna, which an officer in that situation killed a suspect while attempting to shoot at the engine block of the car. And in the process of shooting at the engine block, what some people have said should have happened here, that they should have done something to disable the vehicle. But while shooting at the engine block, they killed the suspect. And the court said that that these police officers were granted qualified immunity. In other words, they were not in trouble for doing that. So help us understand. I mean, one of the things that we've been talking about just informally is it the law that needs to change because it allows police officers to behave in the manner they did when it came to Mr. Brown?
Well, obviously, it's policy and lobbies before the United States Senate, Congress, in order to push forth the George Floyd Act, which would eliminate qualified immunity. But beyond that, let's talk about the law. Qualified immunity applies when the law is clearly established at the time and that's a violation. Well, if we're going to talk about fleeing or people that's a threat and not a threat, all you have to do is look at Tennessee versus Gardner. Tennessee versus Gardner in 1985, there's still good law today to tell you that you cannot shoot a fleeing suspect. It is not better to kill them than to allow them to escape. So that law is binding precedents across the nation, across the land, and even law enforcement actually talks about Tennessee Gardner. I know when I went through the law enforcement academy in Charlotte, North Carolina, Mecklenburg County, that we talked about Tennessee Gardner and how it applies to doing your job as law enforcement. But objective evidence, when you talk about qualified immunity, no case is alike. The courts in this case will look at the most objective evidence. They will look at the video. They don't have to look at they don't have to read affidavits, depositions. The courts get an opportunity to see what was on scene. And I believe once the courts, the Supreme Court or the District Court of North Carolina or the Court of Appeals, whatever court we end up in, will look at this video and see there was no imminent threat. In fact, there was no threat. And you cannot get around Tennessee Gardner, which is binding precedents, for arguendo purposes. If you say that, well, he could have been going in the direction of the officer, I'll contention that he was not. Once he got past the officers and they continued to shoot and fire their weapons, you have force continuum. You cannot continue to shoot in perpetuity just because you believe this person was a threat at some point. The video is clear. The courts will see the video. Hopefully a jury will see the video and they will make a decision. So the law that this DA is referring to, qualified immunity, no way, no how. He don't understand the law as pertains to civil litigation, as it pertains to qualified immunity. That's my job. He looked at the video. He must determine the criminality. He failed to do so. And if he can't determine criminal charges, he definitely should not be talking about civil qualified immunity because he's not qualified to do so.
You know, we all saw in that press conference about a little over 40 minutes of this video from different angles, 40 minutes of the same incident, but from different police officers. And I have to admit, you know, I watched the press conference and saw the video. And then later on, when I watched our correspondent Jeff Pegues' story, I saw the video differently, I have to admit. And there is something to be said for watching, you know, the video once and trying to come to some sort of conclusion. Would you like to see more of this video released to the public? Do you think that would, do you think people would see something different if they saw more of the video? And would you like to see, you know, the department of the DOJ get involved in this investigation as well?
All right, let me answer that question. One, the answer to the question is yes. We have petitioned the courts for the full release, unredacted version of the video to the family as well as the public. That was filed yesterday. All right, there's no reason for them to keep the video at this point, considering that the DOJ is not going to bring charges. We also request the State Bureau investigation report along with our petition that was filed yesterday. So we're waiting to be heard on that particular matter. Additionally, if the DA, he cherry-picked what he wanted to show, but what he picked still shows an unjustified shooting. I think as a layperson, and no knocking anybody, just don't have legal training, that if you listen to somebody giving a narration, they only show you bits and pieces, and they say, hey, well, look, here, he was coming at the officer and pause it. But when you look at the totality of the entire video of what he showed in the continuous running, you won't see it. You will not see a justified shooting. I don't think, honestly, I don't even think it's a close call. And I'm not even taking a position just because I'm a family attorney. I will look at cases in an objective stance to view as well. I think this is a justified act or unjustified act. It's not even close. And the reporters yesterday, after the district attorney got finished with his statements in his press conference, they laid in on it. They asked him the question, and he didn't want to answer those questions because he wanted them to believe what he was saying, not what they were seeing. As for the Department of Justice, you're absolutely right. We engage with the Department of Justice. The Department of Justice launched a investigation on this matter. They launched it, I believe, April 26, 5 days after the killing of Mr. Brown, and they are still moving forward their investigation, despite of what the district attorney had determined that there's no charges being granted. I believe their investigators is more broader than just the shooting, but also what led up to the shooting. It may reveal a reason why they was there in the first place, other than what the district attorney stated. So we shall see.
All right, Attorney Harry Daniels, thank you, sir, for your perspective. We appreciate it.
Thank you, guys. I appreciate it.